knowledge. And I just started recording this webinar, so do not worry if you're wondering, is this webinar recorded? It absolutely will be, and you will get a copy of this sent out. And we have people from a lot of wonderful places. So California, Maryland, fantastic. Georgia, New Jersey, excellent. Love it. Love it. All right. Fantastic. Thank you all for joining us today. We really appreciate you. Rob, again, has a wealth of experience in the counseling field, and he has a very deep understanding of technology. He has become a sought-after expert in recommending technological solutions for therapists, and he runs his own counseling practice, and he has over a decade of information in information technology. So his unique combination of skills allows him to kind of bridge the gap between the counseling profession and the ever-evolving world of technology as it is. So he serves as a column editor for Counseling Today, and which is published by the American Counseling Association, and he shares his insights and knowledge with fellow counselors. And he also co-authored a book called The Private Practice Preparedness, the Healthcare Professional's Guide to Closing a Practice Due to Retirement, Death, or Disability. So this just demonstrates his commitment to supporting mental health professionals throughout their entire career and journey. So in this webinar, Rob is going to delve into fascinating intersection of technology and counseling, and again, give you valuable insights and practical strategies that can really revolutionize your practice, whether you're a seasoned therapist or you are just starting out. So without further ado, let's welcome Rob. Thank you, Rob.
Hey, everybody. I wish I could see your faces, but in this age of virtual presentations, I can't. But hello. I hope you all are having a great day, whether it's morning or afternoon for you. I will let you know I have 3 monitors I work with while I'm presenting with my notes and seeing your chat. So if you see me looking to and fro, I'm probably looking at comments and questions you may be throwing out and my notes and things like that. And I do plan to we got a lot of ground to cover, but I hope to allow a few minutes in there for some questions at the end. So feel free to type them into the chat and I will try to get to as many as I can. I know that the ICANotes folks would like to show you some things at the end of the presentation as well. So on we go as soon as I get the right screen showing. So as she noted, I've been around IT a while. If you don't recognize, I typically show this and ask the audience if anybody recognizes this machine on this slide. It's been very rare that anybody has known exactly what it is. That was one of the earliest devices that allowed you to connect with a remote computer and actually do some computing. You'll notice that it does not have a screen. Everything happened on paper. This is called the Silent 700 terminal, created by Texas Instruments back in the 80s. And my mother would bring this home. She worked for Honeywell on the space shuttle project. And she would bring this home. And after she was done doing some work, I could connect to this computer at Honeywell and play games. So that's my introduction to computers. And I've been around them ever since. Today, we're going to talk about a lot of different things. I'm going to be moving pretty quickly, especially through the first slides, because I have a lot of information that I want to provide to everybody. And these first slides, we're going to be talking about myths, some things that I hear people still have misunderstandings about. And the first few we're going to go through, I hope you already understand and have clarity about, because they're pretty basic things, but they're also things that all the other things we're going to talk about build on. And so I want to make sure. And in addition, I don't know, we probably have some people with us today who are seasoned professionals, and we may have others who are new into the field and still learning about things they don't always teach us in graduate school, like details of HIPAA and technology and ethics of those things. So let's move right in. Myth number 1, technology isn't safe. We hear pretty regularly about hacking and people getting data they're not supposed to get a hold of, and different entities gathering our information. And this isn't a specific quote from any particular person. It's kind of an amalgamation of all the things I've heard through the years. Hey, with all of these things happening, can we trust technology at all? Most of you have probably heard of Edward Snowden. He basically was a whistleblower about some activities the NSA was participating in, basically spying on US citizens. And people have a lot of mixed feelings about Mr. Snowden. Ultimately, one district court ruled that he had to pay the government money, any money that he made from his speaking engagements and book publications, because he violated his non-disclosure agreement with the NSA. He gave out secrets about what they were doing. But in a federal court, they ruled that the program he exposed was probably illegal and unconstitutional. So it's a mixed bag. But in the end, the important thing is he knows a lot about technology and what technology is safe. And he himself said that technology can actually increase privacy, but not if we sleepwalk into it without considering the implications. So whether technology is safe or not has a lot to do with how we use it and whether we're doing due diligence in making sure that it's secure. And that's what the role that HIPAA plays. HIPAA gives us some very loose guidelines about how we keep our digital information safe, protected health information. And the reason it gives loose guidelines is because it has to apply to everything from some of our small solo private practices to large hospital organizations. So they can't ask solo practitioners to do the same things that a large hospital might be doing. So our next myth. Hey, I have everybody sign this privacy notice, so I am compliant with HIPAA. Not true. You have a lot more you need to do to comply with HIPAA. That is primarily associated with the privacy rule, but then we also have the security rule, which is focused on keeping information, protected health information, digital information safe, where you have to do additional steps like do a risk assessment. What are the risks of storing client information in this particular EHR or in communicating via text and those sorts of things? It's about having policies and procedures for, hey, how do we make sure we're using strong passwords, and how do we secure the devices that we're using, as well as informing clients of what their rights are according to HIPAA and how we're protecting their data. So there's a lot more than just having them sign those privacy notices. Interestingly, and don't quote me on this, this is not a done deal, but there has been significant talk about the requirement for that notice of privacy practices to actually go away. There's been talk that that will at some point no longer be a requirement, the assumption that HIPAA has been around long enough and we have other reasons that we need to do informed consent around those things, that they will remove that, quote, undue burden of having everybody sign that every time you go to a new clinician. And sometimes clinicians will have you renew it every year and so forth. It's not a done deal yet, though. Keep having people sign those privacy notices. Another myth. Okay, I'm using really strong passwords, so that makes me compliant with HIPAA as well. Well, I do encourage you to use strong passwords, but we need to also remember that HIPAA requires us to do three levels, three distinct areas, categories of safeguards: administrative, physical, and technical. So administrative is your policies and procedures. This is who's allowed to access information. This is how we set secure passwords, all the rules and regulations we set, even as a solo clinician, to make sure we're keeping data safe. Physical safeguards. Okay, I use my laptop or my mobile phone for some of my work. How do I physically secure that device? Okay, I'm not going to ever, leave it in a coffee shop as I leave. I'm not going to leave it out in a waiting room. How do I make sure that is always in a secure location? If I leave things at the office, how do I make sure they're physically secured? And then technical safeguards are things like using encryption wherever possible. So to be HIPAA compliant, you really need to be addressing all three of these areas in your practice. A note about passwords, though. Not only are strong passwords not enough in the sense that you need to cover these three areas, but I also always strongly encourage people to use two-factor authentication. Two-factor authentication is when you not only have a password, but you have another code you have to enter, typically generated by something like Google Authenticator. Some entities will send you a code via text. So this is an additional code you have to enter in addition to your password. Often when you're accessing that information from a new device, a lot of these will say, hey, enter your code and you check this box and you'll be fine for 30 days without having to enter another code. The reason two-factor authentication is so important, even if someone gets a hold of your password, they won't be able to get in because they don't have your device or other mode for entering that second code. Another reason it's important, in encouraging people to create strong passwords while also remembering them. You don't want to use the same password for multiple sites, for example, and many of us have lots of sites we have to create passwords for these days. I strongly encourage people to use password managers. You may or may not have heard that LastPass, one of the major password managers, had a breach last August. Now, that doesn't mean that passwords themselves were breached. The encrypted passwords were breached. And in today's computing environment, it would take an inordinate amount of time for those to ever be cracked. But there was a lot of other information, email addresses, websites visited, those sorts of things that were breached. So again, even if somebody were to be able to get a hold of that and manage to crack the passwords, if you're using two-factor authentication, you still have that additional layer of protection. All right, let's move on. All right, that's all well and good. Some people say, I don't have to comply with HIPAA because I'm not a covered entity. I don't file electronic insurance claims. So there's some truth in there in the sense that HIPAA talks about it. HIPAA applies to covered entities. And in our work, a covered entity is somebody who does a covered transaction. And the one that primarily applies in our work is filing electronic insurance claims. So technically, by the letter of the law, if you don't file electronic insurance claims, you're not a covered entity and therefore don't have to follow HIPAA. But the issue is we still have a responsibility for protecting that information, whether it's because of our codes of ethics. And I've got 3 of the major organizations listed here, but there are others, including marriage and family therapists, who all say, hey, somewhere in there, whether directly in the code of ethics or in some interpretation that's been released, says, hey, we all have a responsibility for making sure we are securing electronic data. The question becomes, okay, how do we know we're doing that correctly? What's the standard? And ultimately, HIPAA has been accepted as best practices, the standard of the land for, if someone were going to come to you and say, hey, can you prove to us that you're securing your protected health information? And you say, well, I'm doing all the things that HIPAA says that I should be doing. You're probably in good shape. In addition, there are often state laws. Many states have passed their own data security laws such that even if HIPAA doesn't apply to you, those data privacy laws of your state likely apply to you. So that's another incentive for, if not following HIPAA, making sure you're at the very least following your state data privacy laws. And I have this APA record-keeping guideline here. It's just one example of how one of the organizations has said, hey, this is how our code of ethics applies to electronic data. Okay, you got all that down. And I have a typo in the slide up there. It should say software. Using HIPAA compliant software equals compliance. So this is the idea that, hey, I'm making sure anytime I'm using some third-party software that they say that they're compliant, and so I should be good, right? Again, that vendor can only do so much toward their compliance. They can do all the things they're supposed to do. They can use encryption and secure backups and various physical and administrative and technical safeguards they need to do to stay compliant. But they can't force you to use a strong password, for example. So you're still responsible for doing the things on your end for making sure that you comply with HIPAA. If you log into your EHR on a desktop that's in a waiting area and then you walk away, there's nothing the EHR vendor can do to prevent somebody from walking by and starting to use that. So you still have responsibility on your end. It's not a matter of just using vendors that comply with HIPAA, although you certainly want to do that anytime you're dealing with protected health information. This myth went away pretty quickly during the pandemic as more and more people dove into telehealth and learned all the rules and regulations around it. There are still some people who have questions about this. Well, I've got a client that's moving out of state, going away to college. Can I keep working with them? Unfortunately, there's a lot of gray areas here. The general legal consensus is you have to pay attention to laws both in the state you are located and the state that your client is located. And you get into interpretations of, well, what if they're just there on vacation versus actually establishing a residence? It's absolutely important that you find out what the laws are in both locations. It's important to remember that licensure boards are not there to serve us. Licensure boards are established to protect the public. They're established to say, okay, we're going to make sure professionals do what they're supposed to do to become licensed, continue to act in a legal and ethical manner going forward. So they are there to protect the public. So if someone is within their borders, they are taking on the responsibility of saying, hey, we're going to do what we need to do to protect people on our borders. And if you're not licensed here, that brings things into question. And again, different states have different ways to approach that. We also have things like SIPACT and the Counseling Compact initiatives that are creating an opportunity for us to be licensed in more than one state. We're not technically going to be licensed in them so much as the compacts say things like, hey, if you're licensed in any participating state, then you're viewed as being licensed in all these other participating states. And the great news is these initiatives have really taken root and growing, and will be great for us to address these situations where we might need to provide services across state lines. So I encourage people to stay abreast of what's going on with these initiatives, because we're going to have, going forward, true licensure portability, which is really great for the profession. This one, so all phone lines are exempt from HIPAA. So for a long time, we were pretty clear about regular traditional phone lines. So the ones that plug into the wall that a lot of us don't use anymore. And then during the COVID public health information, a lot of exceptions were made where they said, hey, look, if you need to use the phone for sessions, this, that, and the other thing, it's okay. We're in a public health emergency. We want to make sure that people are getting the care that they need. But the folks that take care of HIPAA, the OCR, the Office of Civil Rights, posted some clarifications last summer. They knew that the public health emergency was going to likely come to an end. And in fact, it has. Just recently, earlier this month, the federal public health emergency has ended. So all of the exceptions that were connected to that are gone. But last June, the OCR said, hey, we need to do some clarifications around the use of telephones and such for the provision of healthcare services. So when they talk about CSP here, they're talking about cloud service provider or internet service provider. So anybody that you're receiving services through digitally, whether it's a EHR, a telehealth video provider, or a voice over IP phone service. So it's at first important to understand what a conduit is. So there is what's called the conduit exception, which is why you don't need a business associate agreement with an entity like the Postal Service, because the Postal Service qualifies for the conduit exception, meaning you may mail some records. That's protected health information. You may mail some records to somebody, but the postal office doesn't really have access to that information. They're just transporting it without ever actually accessing the information. And therefore, services like the post office, UPS, they qualify for the conduit exception. And for a long time, there was this gray area that, okay, maybe that's the same thing for cell phone companies and cloud service providers. If it's encrypted from end to end and they never have any access to it, maybe they too qualify for the conduit exception. However, the OCR clarified last June that no, all of these people, HIPAA applies to them as well, these cloud service providers, unless it's very clear that they are only having transient access. That means very temporary access of encrypted data. Then they can qualify for the conduit exception. So one of the examples was for a long time Signal. Some of you may be familiar with Signal as a secure texting app. And for a long time, they touted themselves as something you could remain HIPAA compliant with because they have no access to the text messages that you're sending back and forth. However, they recently backed away from that because of this clarification, because they don't sign a business associate agreement and don't do the other things that they need to do to comply with HIPAA. And they don't just have transient access. When you're texting via Signal, you've got static information that stays stored on the servers, like the two people that are in contact and some of the messages. So a big gray area still are things like cell phones, because the OCR did say this includes cell phones when they clarified. They also laid out some further specifications, which if you've done any training in doing telehealth, you should already be aware of. You need to be in a private setting. You need to verify identity. These are all things, if you've done some telehealth training, you should already be aware of. But the HIPAA police also clarified and said, hey, this is important with regard to HIPAA as well. But they also said the things these clarifications were coming out with don't apply to traditional landlines. So those are the old school Ma Bell landlines where you plug into the wall. But it does apply for voice over IP, cellular, and Wi-Fi. They've released some additional clarifications that make things even more confusing, that make it sound like if you're just doing brief phone calls to set appointments and so forth, cellular might not be an issue, okay? But if you are conducting actual verbal therapy sessions via phone, then it does apply to cellular. Still waiting for some further clarifications on exactly where that line is with regard to HIPAA. In the meantime, different cell phone companies are taking a different approach to this. So you might want to check in with your cell phone provider. I've heard some that are coming right out and saying, look, we'll take care of this for you right away. We'll have you sign a business associate agreement with you. We will comply with HIPAA. That way you're covered. I've heard from others that say, well, we still feel like we qualify for the conduit exception because we only transfer the data. We don't have any case law. So case law is when something goes to court, a judge or other entity has to actually look at it and say, how does this law apply in this situation? So we don't have any case law to say where exactly is that line. So it's important that you continue to watch for further clarifications, do due diligence in addressing if you have an obvious situation like a voice over IP system that you use where people leave voice messages for you about their care. You want to make sure you're doing everything to comply with HIPAA, including using services that offer a business associate agreement. All right, I do see some questions coming in. I'll try to fit in as many as I can after I get through some of these other things. And I think we're doing pretty good on time, so I'll be able to get to some questions. Another myth, I don't have to provide good faith estimates. Again, I've heard various reasons people think it might not apply to them. This is attached to the No Surprises Act. The goal here is for people to not suddenly get a very large bill that they weren't expected related to medical care. Personally, I think it's very unfortunate that this is attached to mental health. We've already been doing this. We are all required by our codes of ethics and often state law to disclose our fees to our clients ahead of time in our informed consent, sometimes on our websites. So we've already been doing this. So it's unfortunate that now they're coming in and saying, well, you got to take these multiple extra steps. But it does apply to us. I've heard some people say, well, I'm not a HIPAA covered entity. this applies to everybody, whether you're a HIPAA covered entity. If you are providing medical services, including therapy/counseling, it applies to you. Even if you've already addressed it in your informed consent, because the No Surprises Act requires you to take a few more steps than we would typically include in our informed consent. So for example, you have to provide it in advance. So before services even start, it has to be client specific with their name and date of birth and CPT codes and diagnosis. And I'll mention something about that in a second. It has to include our details, our NPI, our tax ID. It also has to be clear that's an estimate, not a contract. Strongly encourage you to not, and I've taken this from an attorney who advises, don't have people sign good faith estimates, because then it takes on the appearance of a contract, as though you're saying, yes, this is absolutely exactly what's going to happen, and the dates we're going to, how many times we're going to meet, exactly what's going to cost. It doesn't allow you the opportunity to change any of that information, because GFEs are set up to be updatable. You can say halfway in, wait, my fees are going to change, or we're going to meet less regularly than we talked about. You also have to include information on how they can handle disputes, and you also have to keep it in the client record. So note about diagnosis. This is a major issue for us. It would be unethical in most cases for us to provide any diagnosis before we've even met this client. So that's something where obviously our professional organizations are lobbying for. They're not only lobbying for potentially getting us out of having to provide this to begin with, because we already do this through informed consent, but addressing some of these things that obviously do not fit our profession, like having to diagnose somebody before we've even met them, or even guesstimating how often treatment and how long treatment will be. That's something that, again, this is driven by the medical model. Hey, I need to have this surgery. The doctor should know what's entailed in doing this surgery and what the recovery time is. They should be able to give me an estimate of that, let me know what it's going to cost, and not end up giving me some surprise bill at the end. It just doesn't apply. By the way, important for me to also note that this currently only applies, note at the top, if the client is uninsured or self-pay. So they might have insurance but are choosing not to use it and go the self-pay route. In those two situations, this applies. Currently, the plan, and I've heard fluctuating dates, it's already been delayed before. The plan is this for this to eventually apply to clients who are using their insurance as well. But that has not been implemented. So for now, you only have to supply this to the uninsured or self-pay clients. And again, I encourage you to communicate with your professional organizations, see where they're at with lobbying for changes for this, because it's an extra step we have to take that I don't find particularly beneficial for clients, because again, we're already telling them our fees up front if we're operating within our code of ethics. There are no outs with some of our other regulations. There are other ways for our address things. Some additional caveats to doing good faith estimates. It can only cover a 12-month period. You can't say perpetually that this is my rate and I'll just change it if I need to change it. It can only cover 12 months out. Clients have the right to choose whether they get a paper or electronic version. And you can integrate it into a standing document. So if you decide, hey, I want to just kind of melt this into my informed consent in some way, you can. Just keep in mind the challenges of doing that when you're having to include all that personal data, right? You're having to include the client name and date of birth and so forth. And you have to maintain these for 6 years in the client record. So another great reason to do things electronically as much as possible, so you don't have extra paper you're having to track. All right, we're going to move on to talking a bit about open notes, also known as information blocking. The true technical name for this is information blocking, not open notes, but most people have colloquially been hearing about it as open notes. The idea behind open notes, or the information blocking rule, is to make clinical data more accessible to clients, having them be able to go in and access their data. I know that I personally have gotten a lot of value out of going to physicians' offices, and whether I'm just doing my yearly physical or something else, being able to go in and see, hey, what do the test results actually look like? And what were the results of this other procedure I had done, and so forth. So that's the idea behind this, to give us all better access to our own medical data. Now, obviously, we get into a whole range of issues in our field about, well, what notes do we actually want our clients to be able to see? But the basic rule of the information blocking rule is if the notes are in an electronic system and the client, that system has the ability to present that information to the client, then they need to be able to access it. So the myth is, oh my gosh, I'm going to have to switch EHRs or change EHRs or demand that my EHR add these features in order to meet the demand. That is not true. You do not have to fulfill the open notes. You do not have to address information blocking in the sense of giving them access that isn't possible. So in other words, if your EHR doesn't have the ability to share those notes with the client, then you don't have to switch to one that does allow you to understand. And there are some requirements you do have to make, and I'll come back to that point in a second. There are some broader rule changes that we have to be aware of that aren't necessarily directly associated with open notes. One of them is that we are going to have to start responding to records requests within 15 days instead of 30 days. Again, a lot easier to do if you're doing things electronically. There's also guidance coming. This is not official yet, but it is likely to be that at some point we won't be able to charge a fee anymore when providing electronic protected health information. So a lot of states already regulate your ability to charge fees for paper records. Hey, you can charge X amount for paper records. So this guidance primarily applies to electronic protected health information, that they're going to say, hey, you can't charge people for this. Not a huge deal if you're using a system that already provides that access. And as I mentioned earlier, they're already talking about potentially dropping the need to get a signed notice of privacy practices from clients. So some quick additional information about open notes / information blocking. It also applies to software developers. So any EHR developers that are meaningful use certified. And I don't have the time to go fully into that. But those are the ones that went through the process of becoming certified, a certified EHR for meaningful use, and any healthcare workers. So that's all of us, HIPAA compliant, HIPAA covered entity or not. It addresses electronic records, not your written records. Okay. And it includes all of those electronic records. Here's a very important point. This is not giving any new rights of access to clients. Clients already have the right to access their clinical record. So we've already had to talk about and think through, what do we do if a client requests their records and we're not really sure, it might be harmful for them to read everything that's in their clinical record. That's something we've already had to struggle with and consider and think about the ethics and clinical implications of. So this is not new. It just puts it in a new paradigm. Now they can request that information electronically. Doesn't change what their rights are. It just changes how they might be able to access it and how we might need to provide it. There are no set penalties for violating this rule at this point, which is a bit concerning. We don't know what they'll do if a complaint is filed that you were information blocking, not providing records that were requested or what have you. I have not heard any recent updates on that and how that might look. Good news is it's pretty hard to make sure you're not violating it. There are some exceptions, but they are very narrow, and including all the COVID-related exceptions went away last October 6th. So there are two major exceptions that come from HIPAA. One is psychotherapy notes, if you're not already aware. We have our clinical notes, and we have our psychotherapy notes. Clinical notes are the minimal necessary notes we take to satisfy insurance requirements, to say this is what we're doing, this is why we're doing it, these are what the outcomes are. Psychotherapy notes are more your personal notes, things you want to remember, things the client might have said, diagrams you might draw to help you conceptualize things. Those are your psychotherapy notes. Those are not included in the record and compiled in anticipation of court cases, basically. And then again, that's not new. This is stuff that has always been around with regard to HIPAA. These are some additional, I want to leave time for some questions, so I'm not going to read everything on the slide, but there are some additional rules about how you must meet the client's request if it's feasible, and what are your options. Like, you can talk to the client, hey, client, is it okay if I provide you a summary instead? I think it would be more helpful for you to read a summary of treatment, or to provide this other provider or entity you're wanting to provide records to with a summary. If the client agrees to that, that's all acceptable as well. But if they ultimately hear what you have to say and say, nope, I want my full record, then you have to supply it. Again, that's not new. That's always been a HIPAA thing. This is now extended to how you supply electronic records and don't information block. This is a chart you can find, and I will get with the ICANotes folks and send a resources document so you can find some more details about some of these if you want to dig deeper in. These are some of the exceptions to information blocking. They're very narrow. They have to do with preventing harm, and you have to be able to, document that it would be harmful to release these records. Again, these are not things, I'm not getting into super detail because these are not things that are new to us. It's just presented in a new angle. There are two different kinds of exceptions, reviewable and unreviewable. So a exception that's unreviewable is one where the client can't say, you know what, I'm not too sure about this, I'd like somebody to review this. So this is a list of things, and most of them have to do with court cases or criminal activity, some other law or regulation that prevents that information from being disclosed. Most of the things we might typically be concerned about, like potential harm and those sorts of things, are reviewable. This is where you want to be very clear about how this is interpreted in your state, because some states have passed laws that modify this. The general idea of information blocking is that the healthcare professional can determine who is another professional to review the denial. So you've decided, I think this is going to be harmful for the client to read this entire record. I'm going to choose another professional. The client has said, you know what, I want this reviewed. I don't know that I believe it'll be harmful for me to read this. You choose another professional to say, can you look this over, review this, approve whether this is really something that should be denied or not. In some states, however, California and Washington are two examples. They have created laws that say, no, the client gets to choose the person that reviews the denial. So make sure you are in the know about how your particular state handles any of these reviewable denials. And these are some details about, hey, when does the prevent harm exception actually going to apply? And there's kind of a drawback in here, because all of the references in the law talk about tend to talk about physical harm, substantially reduce physical harm. They don't do a great job of leaving the potential for emotional harm, other forms of abuse. I think this will develop over time to incorporate those things. Certainly, if you ever find yourself in this situation, I encourage you to consult with an attorney. Most of our liability insurance policies allow for a legal consult. So if you ever find yourself in this situation, I encourage you to take advantage of that. last myth, and then I'll take a few questions. There's this concern that we're going to be replaced by artificial intelligence and online providers. This is an actual quote from a entity called Coco, a co-founder of a service that was actually trying to incorporate AI in forms of mental health care services. Except it turned out that they were doing some unethical things and soon became a non-entity. I think most of us have seen the significant increase in online services attempting to become a thing, whether it's Talkspace, BetterHelp, and so forth. We got a couple of issues with AI. One is this is a model of progression of artificial intelligence. We are only just now branching into level 3. So when you hear about chat GPT, you hear about Bard, they're really still level 2 responsive reactive. So they can respond to prompts, they can present facts, but they're really just now delving into, okay, things that can actually have their own awareness, right? Their own ability to think through problems and present unique solutions, as opposed to just spitting something out that comes from their internal database. So we're a long way from getting to where an AI has the self-awareness that we do as clinicians to pick up on things like social cues and emotional states and so forth. So I wouldn't be too worried about that. In addition, we've had many times throughout the centuries and years of new technologies coming and deciding, oh, this is going to totally replace this old mode of doing things. And I think the same thing applies here. We're not going to suddenly all be replaced by online therapists and machines. If your experience is anything like mine, there's been a surge of people wanting to get back to in-office appointments, in fact, as the pandemic has come to an end. So don't think that's a major concern. All right. Looks like I've got time for some questions. And I know I went through all of that really quickly, but there were a lot of updates I wanted to make sure that we got to. And I'm going to look in the Q&A and see what we got. And feel free to throw in some more questions. I need to move this to another screen so I can see. All right. Oh, I see some people from Charlotte. Not too far. Let's see. Is there any form of HIPAA-compliant text messaging that can be used for brief patient communications? So again, your key for HIPAA compliance when you're dealing with electronic protected health information is you obviously need to do all the things for HIPAA compliance, but you need to use a service, a vendor that is HIPAA compliant. So they need to sign a business associate agreement with you saying, hey, we are doing all the things that may make sure we comply with HIPAA. We're encrypting all of your transmissions, not only in transit, but at rest, meaning when any of this information is stored on a server, it's also encrypted there. And that's just one of the many things they would have to do to, comply with HIPAA. But you want to have a server anytime you're doing, this is not just texting, this can be secure email, your EHR. You want to choose vendors that will sign a business associate agreement with you saying we are doing all the things we need to do to comply with HIPAA. And then, of course, you still need to be doing your part on your end. If you're using a perfectly secure texting system, but you lay your phone down on a table at Starbucks unlocked and walk away, you're not complying with HIPAA at that point. So keep in mind, part of it is using a HIPAA compliant vendor, part of it is doing your part for staying compliant. Somebody asked about cell phone providers. I think I answered that after that was posted. So if there's a further, more detailed question about that, let me know. I see questions about recording that I believe. Would you give 3 reputable password managers? I think LastPass is potentially still a good choice. I moved away from it because of the way things were handled by them. I moved to 1Password. I've also heard good things about KeyPass. Dashlane is another one. Again, I've not fully assessed or reviewed any of those, but 1Password. So those are some you could look into. Somebody asked about Google Voice. So yes, Google Voice is a cloud service provider. And unless something has changed recently, my understanding is that Google Voice is not included in Google's business associate agreement. So you can purchase the paid, I think it's called Google for Workspace now. They change the name of it every couple of years. If you've got a paid account with them and you've signed the business associate agreement, certain parts of the Google Workspace is covered by that business associate agreement, but Google Voice is not one of them. So if you have a client, Google Voice has a couple of challenges with HIPAA. One, it will translate voicemails and as well as storing the voicemails. So you cannot at this point technically comply with HIPAA if you're using Google Voice to basically accept voicemails and so forth from clients. Definitely not, conducting sessions over that. How are we doing on time? Do I have time to answer another question or two?
Yeah, absolutely.
Can you give names of some HIPAA compliant text and email vendors? So text is a tough one. I'm pretty sure that Spruce, which isn't just text, and again, I'm just rattling off some names of vendors I'm aware of, not that I have fully vetted and necessarily recommend directly, but Spruce offers a number of services, including text, email, and voice services. I'm a big fan of Hushmail myself. Full disclosure, I am an affiliate, but that's because I've been using them for something like 12 years. That's just for secure email. I'm not aware of other text. iPlum is another voice service I've heard that might also offer text. I'm not sure.
Oh.
Are you two seeing any questions in there that maybe I haven't gotten to?
No, I think you've been doing a great job with the questions.
Steve made an important point that keep in mind this is state dependent. He raises the point that psychotherapy notes can still be subpoenaed. That depends on your state, so you certainly want to be aware of how your state handles subpoenas for psychotherapy notes.
Absolutely. That's a great point. And I do want to add, and I'm going to bring up the ICANotes program now, but I do want to add that within ICANotes, we have the secure text messaging. We have secure messaging. So if you need to send records to other individuals, you can do that through ICANotes. It's actually very, very easy. And we also have where your appointment reminders in text messaging will go to your appointment reminders will go to the patient portal. So there's a couple things, and within ICANotes, we have things that will help you again make your life easier. One, on the documents, you can send multiple documents out. So I can send those out just to an individual, whether it's an insurance company, whether it's another provider, or you're transferring care, whatever that might be. You can send that out, and then also just a couple things that you touched on that I want to show the features that we have within the program. One thing that you brought up was the good faith estimate, which I think was really important. People have a lot of questions around that. We do have good faith estimates within the program. They will go ahead and include some of the requirements on the good faith estimate, like the patient's name, their date of birth, their unique ID number, their diagnosis. And you can even drop in what practice it is, and it will have this good faith estimate here with their diagnosis. So you can enter that because that's supposed to be on the good faith estimate. And we even have, if I'm going to delete this note, we even have the good faith estimate with rates. So if you need to put rates on there, we have the ability for you to do that. So another really, really good point you brought up is the one thing that I think people had a lot of questions on is open notes. And we just got a question on that on Grace. So, does ICANotes allow patients to see their therapy notes? And if so, can you show us how? Absolutely. So, let's pretend that we're doing a therapist note, right? We have a couple features in here because we absolutely understand that we need to comply by federal law, but we also understand clinician workflows here as an EMR. The EMR was created by a psychiatrist. So, if I go in and I say something like maybe the client has symptoms of ADHD, and that continues and those symptoms have been worse lately, and let's say they have a short attention span and that's been a lot worse, and they're easily distracted and that's worse, and they're disorganized and they're just avoiding tedious tasks, and I can put things of like impulsivity symptoms, things like that. Maybe I want to put their behavior. I can chart some of that, like maybe their self-care has been reduced, and there's maybe it's a child and their school functioning that's been really impaired, and so their sleep has been, they're having a lot of sleep problems. I can put that in there. If they're doing great, you could put in a normal MSC. The program will calculate that for you. But here is the areas that I think are super important for clinicians. And I'm going to expand my view so you can see that a little bit more. We have a private notes section. Now, Steve brought up a really good point. If you have a savvy attorney, anybody can request to see private notes, but private notes are not entered into your records, meaning if you print this out, it will not go with your records. Okay, so these are your private notes, and you have the ability to type in these private notes, which I think is great for you to kind of look back and reflect on. Another thing that Rob brought up that was really important is psychotherapy notes. You can omit those from records request or notes that do harm. So some EHRs are going to, what they're going to do is, because there are huge fines for EMRs with blocking. So what they do is they'll basically drop all your notes on the portal. They're not going to get dinged for that. So they'll just throw all your notes on the portal. And a lot of therapists are horrified by that thought. And we understand that at ICANOS. So what we do is we don't put notes on your portal, or we actually give you the ability and control of the notes that you want to go to your patient or client. So, like this particular note, if this is a note that I felt like could do harm or is a psychotherapy note, I would omit this note from the records request, meaning this will not go if they request their records. And as an individual clinician, instead of making that decision for you, we give you the choice to make that decision for you and your client. And so I can say this is a progress note. And this will automatically save, and this will not go with a records request. Now, one of the nice things about a records request is I have the ability to look at a records request log. But before I show you that, I want to show you something else that Rob brought up. And he talked about, Rob, you talked about the fact that maybe you could work with your client if they want a record request and send a summary. We have a very nice clinical summary within ICANotes. So if I go to create clinical summary, I will pick what episode of care I want. So if you're dealing with episodes of care, we can turn on that feature for you. If you're not, you don't have to worry about it. But it will put in any medical history, the diagnosis, if they're on medications, it'll drop that in. Any test results, like if you're doing urine drug screens or things like that, that will go in. Allergies and alerts, reactions. If you want it to go in, again, this is the great thing. You get control over everything you're going to put in. Do I want to put medical history in? Do I want to put diagnosis, drug reactions? Things like that. If you had referred out, that would be in there. And then I would go to this area and I could literally pick what I wanted to go in the note. So maybe I have a lot of counseling notes in here. There's certain notes that I want to go in, but maybe there's some treatment plans. And I think it's important to share the treatment plans with them because that's really like maybe the focus of what we're doing right now. I could select those things to go in. So it really is up to me on what notes that I want to go into the clinical summary. And let's just say that I've picked a lot of them and I can just select certain notes to go in there. So let's just select quite a few here. And then it would give me that information and I could go in and pick out, there is my treatment plan. And I could pick out what I did and did not want in those notes to send. So really, you know, kind of looking at what you want the client to see. Now, it's also easy for patients to request their records in the portal. So I want to show you that very quickly. They can go into the portal. They can request it as Rob brought out. Really good point. They can request that via paper, which anything I've showed you today can be printed, right? So no problems there. Anything I've showed you can be sent. to them, or if they request it and they do it through the portal, it's really easy. It's just super easy to go in and send them the notes that you choose to kind of send them. So, records request log, you can keep a track also with who asked for the records and what you fulfilled and what you omitted, and if you received a request and you haven't granted that. So, because if you have a lot of patients, you have a lot of things going on, and there are things you need to set up and keep reminders for. So, we have the ability in the system for there to be reminders of these records requests as well. So really nice features just to kind of help you with your daily workflow because we know you have a lot going on. Um, Tanya said, when will the client be able to have access to their notes? That's a really, really good question. So and I don't want to speak for Rob in this, but the law says that they in a reasonable period of time, but it didn't give you specifics. So in a reasonable period of time, if they ask for their notes. So and we have a really nice functionality in the patient portal for them to be able to request their notes for you.
Well, and the current guidance or rule really is within 15 days.
Yeah. So there you go. All right. So that is how ICANotes handles records requests. Instead of dumping all those notes onto the portal, you get to kind of choose what goes over. Because again, you're the clinician and you know notes that are going to cause harm. You know what notes are psychotherapy notes and are not. And it's not up to the EMR to make that decision for you. So Rob, you're getting a question on, is that business days or?
Yeah, that's a great question. I would assume business days, but you might want to check to be sure. And again, you also want to check your state laws because some states have their own interpretation and may have a different number of days.
Yeah,
But,
absolutely. So
but
I think.
most regulations tend to refer to working days or business days. So
Yeah. So I know there are certain states that have a time period, like whenever information blocking came out, people that lived in California were like, well, we already have to abide by that. That is already a state law. We already have to abide by that. I think I'm not exactly familiar, but I thought it was 21 days there. So yes, all states are absolutely different. I didn't know that there was a federal ruling on the 15 days. So that's really good information to know. Thank you. Right. Any other questions that we have today for Rob? Well, I know, again, your time is very busy. That's why we created ICANotes to help you do your notes and get those done in a timely manner, very quick. Our progress notes take about 2 to 3 minutes to complete. So, and let's see. A good question from Corey. Is there a mobile app for ICANotes that allows for secure text messaging or just the computer version? So right now you can use ICANotes on like tablets, so you're able to do that. But for secure messaging or texting, you have this version. You can go in and manage your patient portal. It's really easy actually to set up your patient portal and to send out text messaging. And I'll just show that really quickly. It's a great question. So within your patient portal, you manage your text messages. Another thing that we do with text messages, and we let you set them up so you actually decide what they say. So here we have the email reminder settings, but we also have the SMS reminder settings. So if you go in, you actually get to pick what you want it to say. Would you want it to say the patient's name, the provider name, the location, the appointment date and time, the days of the week, and you get to set up what reminder time periods you want it to go out. So, what time you want it to start sending out reminders, like 9 a.m. to 8 p.m. Do you want them to send it out 24 hours ahead of time, 48 hours ahead of time, 1 hour ahead of time? And do you want a second reminder sent? Sometimes your patients need a little extra reminder. So, that's okay. You can absolutely send out a second reminder as well with that information. So, thank you so much, Michelle, I really appreciate you. Oh, you forgot how much you loved ICANotes. Well, we love you too. So thank you so much. And a big thanks to Rob and everyone for coming out today. Again, thank you for your time. Your time is very valuable. We hope this was very informative to you today. So thank you guys so much. Have a wonderful day. Bye bye.